Good afternoon. This is the House Judiciary Committee. It is the 14th of March, 2025, and we have a number of bills on our voting lists. We're going to begin with House Bill 130, Delegate Simpson's bill. We've passed this bill in the past. Changes the penalty for wiretap from a felony to a misdemeanor.
Move favorable.
It's a motion for a favorable and a second. Is there any discussion related to House Bill 130? Delegate Grammer.
Thank you, Mr. Chair. I did submit an amendment for this bill.
I do not have an amendment on this bill.
It was sent on February 10th. I sent in the reprint over the last couple minutes.
Okay. What would,
I can explain it if you like.
why don't you explain it, but we're going to need to find it. February 10th you sent it?
Yes.
Explain the amendment, and then we'll see what we're going to do.
So to remind the committee, what the bill does is it changes the penalty for a wiretap from a felony to a misdemeanor. And we've struggled to get this bill across the finish line for several years. A lot of the abuse advocates have really taken an interest in this bill, and they've kind of investigated where the Senate's at with this issue. And they've made a couple suggestions which I've brought forward in this amendment. So the amendment does two things. Changes the statute of limitations to 5 years. It also opens the cap on restitutions, which is otherwise set at $10,000 just for this crime. And that the thought is this would make the bill overall something the Senate would be open to.
And then this is just, sorry, I don't know how to scroll it down, but it's just saying it's the statute of limitations is 5 years.
So it makes the statute of limitations 5 years for the bill, and then it adds probably unconstitutional language on restitution.
You think that's unconstitutional?
Probably. I mean, it's going beyond the scope. You're literally saying that the law that you have on restitution, I mean, maybe it's not unconstitutional, but it's blowing a hole in the middle of the restitution statute. We don't allow people to effectively collect attorney's fees and everything else as part of a criminal action, because it opens the door to a wide range of things that would be difficult to do.
So I attempted to suss that out in drafting, and what you're saying is that language as drafted is not as the drafter said it.
I don't know if it's I'll set aside the constitutional argument. I feel like when you get into the restitution side of this, opening the door that wide allows a lot of things in restitution that really is a separate bill. It's a really separate bill. And so that's why that piece of it, I don't know that I'd be enthusiastic about. The other part is, I mean, the question is, can you remind the committee how long is the statute of limitations right now for?
Well, if it's a misdemeanor, it's 1 year.
For a misdemeanor, it'd be 1 year, so you'd effectively be extending the statute of limitations to 5 years on wiretap.
Oh, thank you.
Okay. I guess that is a valid question. The vice chair.
Just, I wanted to understand your why on extending it to 5 years.
Well, I think allowing for the prosecution is something that balances out the fact that we're taking this from a felony to a misdemeanor. And just to be clear, I've supported the bill in the past. And I think the felony, in most cases unnecessarily ruins a person for no reason. But I think that was the trade-off that was the Senate would be amenable to.
Let me make sure I understand. So you're saying that. Thank you, Mr. Chair, sorry. You're saying that extending it out to 5 years would allow the prosecutor to go after a misdemeanor. And I'm not trying to belittle that. I just want to make sure I understand.
To go after the offense, yes.
Okay. Okay.
I'm sorry, but for lawyers like you, this is all very common stuff. But I need time to, can we push this to the end of the voting list? Because I need time to read his amendment and stuff like that.
We'll hold on to it for a second. We'll take it to the end of the list and come back to it. There's a number of other things that we need to do. The squatting bill.
Yes, colloquially known as one of the several squatting bills. I think we have peace, not in the Middle East, but at least here, where we have amended the wrongful detainer statute. And so the amendments to the wrongful detainer statute would basically say when the petitioner files the complaint, the court must schedule a hearing within 14 days. During that 14-day period, the petitioner has to effectuate service. It has to attempt personal service twice on the person allegedly in unlawfully possession of the property. If they're not able to get personal service on 2 attempts on 2 different days, they can obtain service by posting the summons conspicuously onto the property and mailing the summons via first-class mail and certified mail. The court will hold the hearing on the date designated in the summons. If the judge determines that service was not properly obtained, then the hearing will not go forward. If the judge determines that the service was proper based on the affidavit filed by the petitioner, then the hearing will be held, and then an order, if the court believes the petitioner, will grant an order that will be sent to the sheriff to effectuate the order to remove the person from the property.
So that's a favorable and a second on the amendment. Are there questions about the amendment? Okay, seeing none, all in favor of the amendment, raise your hands. Anybody opposed? Seeing none, the amendment is adopted, and there's a motion for favorable with amendment. Is there any further discussion on the bill as amended?
Oh, and I forgot to mention,
Okay,
the amendments include all of the bill sponsors from all of the squatting bills that we had. So while Delegate Conway is first, we also included Delegate Naraki, Holmes, and Addison as co-sponsors of this piece of legislation.
so they're all squatting on the legislation?
They're all squatting on the legislation, yes.
I'm here another 3 weeks at least, I think. We'll find
So,
out.
Claire, hopefully I got that right, Claire. Yes, okay.
How dare you? All right. Are there other questions on the bill? Seeing none, that's awful. The vice chair?
Yes.
Yes. Valentine?
Yes.
Yes. Crutchfield is excused. Carden?
Yes, and squat.
Are you adding? Carden is adding. Tomlinson? Yes. Embry? Yes. Pasteur? Yes. Tolles? Yes. Schmidt? Yes, and add. Simmons? Yes. Boucher? Yes. Phillips? Yes, and add. Stinnett? Yes, and add. Congolo? Yes. Erican? Yes, and add. Taylor? Yes. Simpson? Yes. Grammer? Yes, and, okay. Sample Hughes? Yes. Oh, we're starting out so well. All the people watching at home, aren't you glad you're not here? Moon? Yes. Conaway?
Yes, and thank you.
Yes, and an add.
You're welcome.
Kaufman?
Yes, and an add.
Yes, and add. Williams?
Yes.
Yes. Do thank the subcommittee for all of your work all the way through the session on this issue. Let's see what the Senate thinks.
I don't think it's over.
Yep. All right. We have House Bill 210, which was held yesterday. I don't have, do I have an amendment? Tell me what the amendment does.
Thank you, Mr. Chair. I think you should have the amendment. I know it's an amendment that Delegate Conaway and I just added. It's just a technical amendment. Just added Conaway and Tolles. And I think there was another amendment sent back once it was completed.
So is there anything substantive to the bill in your amendment?
No, that's the only technical amendment that.
Because if it's a matter of form, we defer to the Department of Legislative Services.
Well, according to the email, they said they defer to you. If you want to wait until the end to so you can properly have the amendment, but let's say the department via the email said to give it to your
I'll
staff.
hold it a little bit longer.
Do you not have the amendment? If you could,
I don't think so. So I'll hold it a little bit longer and we'll go from there. We're going to keep moving.
it's in the packet, they said. Thank
Is
you.
it?
Just a rewrite.
Well, we're holding on to one bill till the end of the session. I'll hold on to this one too. House Bill 579, going to keep going. House Bill 579 is one of two bills on the docket today that are related to issues of immigration. And House Bill 579 has part of the bill that Delegate Embry is more familiar with that has to do with U visas, which are visas that are used by people who have been victims of crime in the country but who are otherwise undocumented. And then there's another part of the bill that talks about sensitive places. And that part of the bill is a part of the bill that Delegate Moon has been working on. And so what I'm going to do is, in two parts, I'm going to go first to Delegate Embry to talk about her part of the bill, and then I'll go to Delegate Moon to talk about the sensitive places part of the bill. So Delegate Embry.
Thank you, Chair. So recap on what the bill does, and then I'll talk about the amendments. So for persons who are victims of crime who are eligible for the U visa, we have existing law that attempts to standardize the process across the state, and this bill adds to that because recognizing and responding to differences in localities and how they're interpreting federal law. So the bill, as introduced, is just reinforcing what federal law and federal guidelines already say to, again, have standardized practices across the state. The amendments, we accepted all of the MSBA technical amendments and reworded, there's some slight rewording based on some of the advocate suggestions, but not very substantive. And then the most significant thing is Delegate Solomon had a great bill on the same issue, so he added in the two provisions of his bill that were not in mine, one of which was to require that certifiers have a process to deal with non-English speakers, and the second was shortening the time that certifying agencies have to respond. Happy to go into any more detail.
Questions about that part of the bill now? Okay, so meanwhile, I heard number two, Delegate locations portion of the bill.
Thank you, Mr. Chair. On the sensitive locations part of the bill, we did a few things. One, there's an existing part of law, Criminal Procedure 2104, where a federal law enforcement officer who can make arrests and carry firearms, this is, again, it's existing law, 2104 Crim Pro, they have to notify the local, head of the local law enforcement agency when they conduct an enforcement action. And so we clarified that that existing law includes a federal immigration enforcement action at the sensitive locations. So again, if the feds are contemplating doing this, they're already supposed to be contacting local law enforcement to warn them, and this just clarifies that that includes these enforcement actions if they're contemplating doing it at a sensitive location. That also reminds us that these are enforcement actions conducted using firearms. Elsewhere in the bill, the sensitive locations Attorney General policy, it gets into a lot more specificity. So it doesn't actually, the original form of the bill, I think, said something to the effect of the Attorney General is going to conduct a memo to limit enforcement activities at these locations. And instead, this takes a much more descriptive approach. And so it has the Attorney General write guidelines that are intended at sensitive locations. And here it's defined as very clearly as a school, a public library, a healthcare facility, a shelter, and a place of worship, that for those locations, the Attorney General guidelines are to maximize public safety and minimize public exposure to violence or accidents from immigration enforcement conducted using firearms at sensitive locations, to minimize disruption to the services provided at sensitive locations, again, from immigration enforcement using firearms. And those two provisions are in line with how we treat warrant service, which is to say, if the sheriff is coming to apprehend someone, we know that that's a dangerous activity using firearms, and so we want to avoid unwarranted harm, danger, and violence to people around them when we conduct those activities. And again, the sensitive locations places specifically are places where it's a school, a hospital, there are other things going on. So we want to minimize the risk of disruption to services and harm to those people when these enforcement activities conducted using firearms are happening. And remember, we're also trying to get them to warn local law enforcement that they want to do this. In addition, the guidelines that the Attorney General would put out would delineate the legal difference between immigration enforcement within a public part of a sensitive location and a non-public or private portion of the same facility. Again, a hospital is a very large place. And some of these, a public library, has bathrooms, it has the back offices where the workers are, it has the public portion, and there could be differences there. It also directs the Attorney General to, in the guidelines, to align Maryland Constitution Article 26 with these policies, because that constitutional provision requires that a warrant name a specific individual. And so again, if they're contemplating collateral immigration enforcement policies where they're picking up not just the individual, but unnamed people that happen to be there, it seems to us that the Attorney General ought to contemplate the Maryland Constitution theory here and set about creating policies that consider collateral immigration enforcement at sensitive locations. It also directs the Attorney General to set guidelines that limit the liability exposure for the state, local, and private institutions and their employees in how they go about dealing with federal immigration enforcement at these sensitive locations. Also sets the Attorney General to put language in facilitating relationships between federal law enforcement and the state and local officials, again, so that these enforcement activities could be conducted through the least dangerous and disruptive means, and also asks for guidance in complying with existing legal obligations and limitations on these state agencies while maintaining public safety and accessibility. Lastly, the AG may develop guidance for non-public facilities. So that's the.
So to be clear, as I understand it, it restates the law that says that if anyone who is a federal agent or a federal officer is going to go onto effectively any property with a firearm, they need to notify the local police department, and that is effectively I guess what's included in the bill, a clarification of existing law that says if you're a federal immigration officer, this counts for you too.
Correct.
And then the second part of it is basically asking the Attorney General to look at regulations surrounding sensitive places,
Correct.
which I said a lot
Correct.
more succinctly than what is actually in the bill.
Yes.
That's fine. What's in the bill is very important. That's why we're here allegedly. But I figured I'd ask. Delegate Arakan, and then Boucher.
Okay, so this in no way restricts their ability to go into these places. They just have to alert the people and sort of make it as least
They're
encumbersome
required to
as
give
possible.
notice already under Maryland law. We would just be making it clear that a federal officer, federal immigration officer, same difference really, but we're making it clear a federal immigration officer has to let them know too.
And do we know if that is that typically how they do business now?
That is, from my meeting with ICE, yes.
Okay, so they would already call ahead and say, we're coming in to pick this person
That
up?
is what I was told, yes.
Okay. Because I just want to make sure that we don't have like MS-13 hold up in a hospital because they know it's the only place they can't go to.
And also, just to be clear, I mean, there's only so much we legally can do to restrict these activities, and especially when you're talking about exigent circumstances. And so the bill does contemplate, however, that, for example, there should be an identity verification procedure. If they're asking for a specific person, there ought to be a document verification procedure.
Okay.
And again, there should be some relationship established so that they're actually trying to avoid doing it this way.
Yeah.
So that they don't have to go to a school, a hospital, or someplace where, least disruptive means.
Yeah, I think we asked him when he was here, he said he's never done that before. They've never even done that, so.
Then they should be fine.
Yeah, okay, all right.
Thank you. Is there an explicit list of what constitutes a sensitive location, or is it more in the interpretation of the court?
I think a lot of these are defined in law, the locations that you're noting here. And, I suppose we could add more clarity. I think they're pretty clear. The bill as introduced was quite a bit more expansive. It was this list plus anything else the Attorney General designated. So we tried to shrunk it to a list of plain language terms that people understood.
Was there any other previous statute that listed those locations, or is this brand new?
This was based off of what us taking was introduced and trying to condense it to a plain language list.
But there was no other previous statute?
We did not align it to a particular law.
All right, thank you.
Delegate Tolles?
Chair, you indicated something about the police would be called, or someone said something about the police would be called instead of immigration, the local police. I missed that.
They're technically already supposed to call the head of local, or the local law enforcement agency in the jurisdiction where they're doing an act, not just an immigration action, anything, DEA or whatever, is supposed to call. And again, it is the chair's understanding, and my understanding also from talking to the ICE field director here, that they do in fact have these relationships and make these calls to the local law enforcement.
And so, I'm sorry, how did that tie into the bill? I totally missed that part.
It is in, I think it's in the front of the bill. Yeah, it's in the very front of the bill. Section 2104 of the criminal procedure article. So on C,
So this is
section
current law?
C1, we are adding a clarification to that law that this includes the sensitive locations actions.
I'm sorry, what page are you on?
It's the first page. I don't have a page number on what I'm looking at. It's page, is that page 2? Or?
It's a part of the,
2 of 6.
yeah.
You said it's page 6?
No, two.
2. 2.
2, okay. And it is, so, okay, where it says 1, the chief of police,
Yep.
so that is adding, so the chief, so the police will go after immigration force?
No. No, this is, all that stuff is existing law about
Okay.
who needs, who do the federal government need to call
Okay.
if they're going to do something. And they call the chief of police. The chief of police doesn't have to do anything to help ICE. They're just getting a courtesy notification call.
And what are we changing it to?
We're just clarifying that the calls that they need to make include these immigration actions. They're technically already covered, but again, to the extent there's any confusion about that, we are clarifying that.
And I apologize, who's supposed to call who?
ICE.
ICE is supposed to call local officers.
The named local law enforcement.
Okay, and that's current law?
Yep.
Okay, so we don't have any indication as to whether, like, if they, like, how much they're doing that now, and if it's any more
We don't have
manpower?
data on it. Yeah.
Okay, thank you.
All right, are there other questions about the amendment? Delegate Embry wants to speak again. Delegate Embry.
Thank you, I'm sorry, I have a question. What, private schools, non-public schools, was that considered and discarded, or? Okay.
I think that's how it was in the original bill. I might be wrong, but I thought that was how it came in.
Okay.
Any other questions? Seeing none, could I have a motion on the amendment, please? Motion on the amendment in a second. Any further questions on the motion that is there to adopt the amendments? Seeing none, all in favor of the amendment, raise your hands. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15. Anybody opposed? 1, 2, 3, 4. The amendment's adopted.
Favorable on the bill.
There's a motion for a favorable on a bill in the second. Is there further discussion on the bill as amended? Seeing none. The vice chair?
Yes.
Yes. Valentine? No. No. Cardin?
Yes.
Yes. Tomlinson? No. Embry? Yes. Pasteur? Yes. Tolles? Yes. Schmidt? Yes. Simmons? Yes. Boucher? No. Phillips? Yes. Stinnett? Yes. Congolo? No. Arakan? No. Taylor? Yes. Simpson? Yes. Grammer? No. Sample Hughes? Yes. Moon? Yes. Conaway? Yes. Kaufman?
Yes.
Yes. Williams? Williams?
Yes.
Yes. Kaufman is adding. Anybody else want to add? Moon? Probably should at this point.
Yeah.
Stinnett? Phillips? Simmons? Seeing no others. The motion is adopted. Move to favorable. Now, House Bill 853. We have discussed the amendments. Could I have a motion on the amendments on the bill?
Second.
All right. The amendment 663024. To be clear with the committee, there was a typographical error in the amendments that we passed out last night. In the amendments last night, it indicated that this would only apply to people who had already been sentenced, that this would be retrospective and not prospective and retrospective. It is both. It is the intent of the amendment maker, that's me, meant to make it prospective and retrospective. There was a typo because we brought the language forward from Delegate Lewis's bill from 4 years ago that included language that would have made it only retrospective. So just to be clear, this doesn't just apply to people who are in prison now. It would apply to people who may be in prison in the future. With that, we are on the amendment 663024. On the amendment, Delegate Tolles.
Oh, no, I don't have any.
Okay. All right. Are there further questions on the amendment? The Vice Chair.
Mr. Chair, I just wanted to make a statement, if I could, really quickly, on the amendment. I wanted to make a statement that the reason why the bill was not voted yesterday because we didn't have the amendment. We had language that described the amendment, but we didn't actually have the amendment. So therefore, we're voting, hopefully, today on the bill.
And we also normally, on a bill like this, we roll out what's in the amendments and what's there, and then we go from there, and that's why we're here. So, okay. Delegate Cardin.
Thank you. And I'll just say, I had spoken to you about this, but for the edification of Delegate Pasteur, My understanding was that we were voting on the bill without that change in the amendment.
I understand that.
Okay, I'm just learning.
No, you're fine. Are there any other questions about the amendment? Delegate Sample Hughes.
Thank you. Just clarifying, is the amendment taking out murder?
I'm sorry?
Is the amendment taking out murder? Yes or
No.
No? Okay.
No, it is not.
I'm just going through all these papers here. Thank you.
No, you're right. All in favor of the amendment, please raise your hands. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12. The chair votes aye for 13. Anyone opposed to the amendment? 1, 2, 3, 4, 5. The amendment is adopted. 6. The amendment is adopted. We are on the bill as amended. Could I have a motion? Second. There's a motion for a favorable and a second. Are there any further comments on the bill as amended? Delegate Tolles. Your light is, okay. Stop playing with your light. All right. Delegate Tomlinson.
Can you just give a quick recap on, because I know the bill's going through a couple different.
So the bill as amended would do the following things. It would allow, it effectively extends a law that we passed in 2021 that gives people who have served at least 20 years in jail the opportunity to seek a modification in court. It becomes up to the judge whether or not they would modify their sentence and change the sentence in some way. The modification would be available only to people who had served 20 years or more in prison, only to people who were not sentenced to life without parole and not sentenced to a crime that would require them to be listed on the sex offender registry. There are a number of things that the judge shall consider as factors when determining whether to reduce the duration of a sentence, including the individual's age, the nature of the offense, whether the individual has substantially complied with the rules of the institution in which they have been confined, whether the individual has demonstrated maturity, rehabilitation, and fitness to re-enter society sufficient to justify a sentence reduction, any statement offered by the victim or a victim's representative, any report of a physical, mental, or behavioral examination of the individual conducted by a health professional, an individual's family and community circumstances at the time of the offense, and any history of trauma, abuse, or involvement in the child welfare system, the extent of the individual's role in the offense and to what extent an adult was involved in the offense, and any other factor the court deems relevant. An individual can file for this modification if they qualify up to 3 times. They have to wait 3 years after a denial or partial grant of a sentence reduction before they can petition again. It also amends existing law to allow the court to consider victim impact statements, as well as require the court to order the defendant to stay away from and refrain from contact with the victim and a victim's family unless the victim requests otherwise. One moment.
Required to consider a victim.
The court is required to consider a victim impact statement, not that they can. They are required. It's a shall, not a may.
And
Delegate Tomlinson.
sorry. And I think Delegate Tolles had thrown out there about adding that if it involved a hate crime, that's.
I don't have any other amendments
We didn't
before
go
me.
with that. Okay. Gotcha.
All right. All right, Delegate Tolles.
I'm not playing with my light this time, but I'll speak. Thank you, Mr. Chair. I'll speak to that. So I will not be doing an amendment on that particular, on the hate crimes. This section is just too big. There are, if I can pull it up, section 3. got like a gazillion icon things open, but the criminal law statute for hate crimes is kind of expansive, and I just don't think that we want to delve down to each little crime. I don't think it's necessary, or the important thing is that we get this bill moving without having to deal with that particular section. I do want to add my continued condolences for the Collins family, and that was for the impetus of trying to do that particular amendment. But that in that case, the judge said that defendant could not be charged, that the element of hate crime was not allowed in that particular case. The judge made that indication. So even if I wanted to do something to deal with that particular case, I'm not able to do that because it would not fit. It wouldn't fall under that case because the judge had indicated that the elements of hate crime did not meet, did not justify charging that individual with the hate crime, which is why the legislature came back the next year and did a new bill to clarify those elements to make, if that ever happened in the future, then we have a new statute in place that would then allow the judge to make that determination. So with that, and I did speak to, some folks in leadership here on the committee about it. And I would say we've got emails and calls about it, but I will not be doing that amendment, nor do I think we should do it because it won't meet what we needed to. It won't necessarily do what we wanted to do. So with that, I will yield, if possible, to the Vice Chair, Mr. Chair. Vice Chair. Thank you.
Thank you. And thank you, Delegate Tolles. I appreciate you considering it. I appreciate the folks from Sergeant Collins' district considering it, because I think it is an important consideration. But there are crimes under the hate crime that go to things like such as destruction of property and some other matters that the individual may not even be charged or sentenced long enough to even fit within the bill. So we don't want to pull in everybody. I think that should be a separate thing that we look at another time. So I agree with Delegate Tolles, and I think that maybe it would be good another year to look at it and see just, what we want to do with the sentencing of hate crimes and how and whether or not we give them a second look at some point, or make sure we make clear what we want to have excluded.
On the bill as amended, Delegate Congolo.
Not necessarily on the bill as amended. I was just wondering if Delegate Tolles could share what falls under that statute, because, I'm just wondering because it does. Oh, I'm sorry, can you hear me? So can you share what falls under that statute of hate crimes? You said it was extensive, and I just wanted to know.
Gave you some examples, but if you look under, I don't want to spend the committee time because we do have other business, but if you look under subtitle 3 of the hate crimes, and I'd be more than happy to share that with you after committee, but I don't want to take up too much time going through each and every section.
So was that sent to us?
No, that was research I did on my own.
Oh, I got you. Okay. Would you mind sharing that with me?
Absolutely, and it was based off when they are Prince Georgians who experienced that hate crime. So it was in an effort to, show some empathy there.
Yeah, no, and I appreciated when you brought it up last week. That's why I was hoping that would be included. That's why I'm hoping to better understand it, because there are some concerns around hate crime. So I want to just better understand.
Delegate Congolo, if you go to section 10-301 of the criminal. Thank you. I'm looking at going, what is that word? Criminal law, subtitle 3, under hate crimes. And it lists, it goes through and lists all of that.
goes through the list of the classes of people and the situations that are covered by the hate crime statute. Delegate Tolles?
So I'm proud to say that this is the Black Caucus priority, and you are a member of the Black Caucus, so I would hope there wouldn't be any other issue when we post this to the floor. If you do have something, please feel free to talk to Madam Vice Chair or myself, who is like you are members of that caucus and can address any concerns. Thank you, Mr. Chair.
Are there other questions? We're on the bill favorable with an amendment. Seeing no other comments or questions, there was we'll do a motion and a second on the favorable with an amendment. With that, the Vice Chair.
Yes.
Yes. Valentine? No. No. Crutchfield is excused. Cardin? Is not there. Tomlinson? No. Embry? Yes. Pasteur? Yes. Tolles? Yes. Schmidt? No. Simmons? Is excused. Boucher?
Yes.
Yes. Phillips?
Yes.
Yes. Stinnett?
Yes, and add.
Yes, and add. Congolo? No. Arakan? No. Taylor? Yes. Simpson?
Absolutely, yes.
Yes. Grammer? No. Sample Hughes? No. Moon?
Yes.
Yes. Conaway?
Yes.
Yes. Kaufman?
Yes, and add.
Yes, and an add. Williams?
Yes, I think I'm already on it, but.
Just in case. 1, 2, 3, 4, 5, 6, 7, 8, 9, 11, 12, 13. The motion is adopted on a favorable. All right. Thank you very much. We're going to move forward. Do I have piles here already? I don't know.
Another Conaway bill?
It's another Conaway bill, but we may need to look at it again. Yeah. So, okay, we just received this from Ways and Means. We are secondary on it. We're going to get to this legislation, but I think we need to look at it a little bit more, and we'll come back. We'll come back to House Bill 993 in a second. We have another bill from Ways and Means, House Bill 1265, where they're, I think, waiting for us. This is about reportable offenses. I am going to say to the committee that we need to, there are a number of changes that were made to the bill as it was initially put in. And so what I'm going to ask the committee to do is look at those changes that were made to 1265. We will probably come back for a voting session in the morning tomorrow. Delegate Grammer.
Just wanted to let you know I just submitted an amendment for that bill. I just got it back from the amendment office, so everybody has it.
You should look at that bill tonight. We will be coming, consider this your fair warning that any amendments need to come to the office as quickly as possible and absolutely before 9 a.m. tomorrow. So we'll hold on to 1265, and again, telling the committee to look at that. House Bill 1420. House Bill 20 has amendments. Who wants to talk about what the amendments on 1420 do? Holly, why don't you come on up? Delegate Cardin's got it, but Holly's here just in case. Well, let's do this while you're getting settled. There's an amendment to House Bill 1420. There's a motion on the amendment. Is there a second? Second, all right. So we're on the amendment now. Tell us what the amendment does.
Yes, Mr. Chair, thank you. The amendment basically strikes the bill and changes it. Hold on. This is so the amendment will basically say that that if it strikes the section of the law that says that you cannot be a non-citizen in order to be a personal representative.
Is that correct?
I was trying to pull it up so I could say specifically, but I'm just telling you what it does. It strikes the part of our code that says that in order to be a personal representative, you have to be a citizen. That's all it does.
Motion and a second already to move the amendment. Are there any questions, further questions on the amendment? Delegate Kaufman.
Subcommittee Chair Cardin, does Delegate Warman view it as a friendly amendment?
Delegate Warman views it as a friendly amendment, and it was drafted by, well, it was drafted, I think it was drafted by her. So yes,
Right.
she's okay with it.
Thank you, that's all I wanted to know.
There was a question as to, because the part of the code that it strikes talks about a specific sort of laundry list, an order of which can serve as a personal representative. However, that is already in the code in another place. So if non-citizens are permitted, they will still have to go through the same list. In other words, the priority goes to a spouse, and the second priority goes to a decedent, and to an ancestor. The third goes to a descendant, and the fourth goes to a sibling. So it's all the same thing. So even though that part is removed from the code, it's already in there earlier for citizens.
All right. Are there further questions on the amendment? All in favor of the amendment, please raise your hands. Anybody opposed to the amendment? Seeing none, the amendment's adopted. And there's a motion for a favorable as amended and a second. Is there any further conversation about the bill as amended? Seeing none. The vice chair?
Yes.
Yes. Valentine? No. I'm sorry? No. No. Crutchfield is excused. Cardin? Yes. Yes. Tomlinson? No. Embry? Sorry? Yes. Yes. Pasteur? Yes. Yes. Tolles? Yes. Schmidt? Yes. Simmons is excused. Boucher? No. Phillips? Yes. Stinnett? Yes. Congolo? No. Erican? Yes. Taylor? Yes, and an add. Simpson? Yes. Grammer? No. Sample Hughes? Yes. Moon? Yes. Conaway? Sorry? No. Kaufman?
Yes.
Yes. Williams?
Yes.
Yes. The motion is adopted. All right. Now, another bill. House Bill 1222, Delegate Williams' bill, has amendments.
Move the amendment.
There's a motion for the amendments and a second. On the bill, no, we're not on the bill, we're on the amendments. So we're on the amendments, and Delegate Williams, can you describe what the amendments to the bill do/say?
Yes, thank you, Mr. Chair. So you should have the amendments in front of you. There's been, I don't know if Hunter sent the most recent version, okay, to everyone, so let me make sure I have that one. If you remember, the original form of the bill talked about a covered individual who was not lawfully present in the United States. We modified that language just to mirror more language that you will find in the immigration statute. So it says, is the subject of an active immigration detainer request and has been convicted. We added on or after June 1st, 2025, because that's the effective date of the bill, of a crime of violence. And the crime of violence as defined in section 14101 of the criminal law article, I can rehash it for you, but it's a whole laundry list. You can check it out at your own leisure. But it's a laundry list: murder, first-degree rape, second-degree rape, first-degree murder, second-degree murder, all of the fun crimes. Also added is any felony under 4-204B of the criminal law article, as well as the use of a firearm in the commission of a crime of violence under 4-204B of the criminal law article. Driving under the influence, engaging in a criminal organization activity, which is basically our gang statute here in the state of Maryland, or has been issued an Interpol notice for criminal organization activity. And you can see it further references the definitions to all of those things in various sections of the criminal law article. If someone has been convicted of any of these things, if requested by federal immigration authorities, an employer or agent of the state or local correctional facility shall provide notice of the release of the covered individuals within 48 hours before the release of that covered individual in order to facilitate the transfer of that individual to federal immigration authorities. And the transfer of that covered individual to the federal immigration authorities will take place provided that the transfer does not extend the time that that individual is in custody, which is important because we want to make sure we're not violating any constitutional basically not violating the Fourth Amendment of the Constitution. And the Attorney General in the past has opined about detaining someone after their time of conviction. And there is an Attorney General's opinion on that, which is why that is important. So that's the first part of the bill. The second part of the bill does then talk about referencing these covered individuals. It also talks about really rehashing the same language as it relates to law enforcement. And then it goes into immigration enforcement agreements, which are colloquially known as 287G agreements, basically stating that any unit of state or local government or county sheriff, agency, officer, or employee would basically, or someone that has a memorandum of understanding with the federal government under these two types of agreements there and the federal code would have to, could not enter into an enforcement agreement of this kind if they have not done so already, or if they do currently have a contract for one of these types of agreements, would have to basically end their existing agreement no later than July 1st, 2025. And those are the amendments.
Questions as to the amendments starting Delegate Erican?
Thank you, Mr. Chair. So there's so much to unpack here. So we're looking at a removal of local courtesy for Frederick, Hartford, and Cecil specifically, and the other counties in which we have pending 287G applications, of which I hear there are several. But what I really want to share is some of the data and why this edit to include crimes of violence is wholly inadequate in terms of addressing what's actually being experienced in our state in terms of violent crime and all kinds of crime committed by people here illegally. I reached out to ICE and they sent me over a whole list of all of the crimes that people had previously committed, but not necessarily been the ones that they were arrested for presently. So, I mean, there's hundreds of them here. 6 people committed homicide, 6 strong-arm rapes. They use different language than we do in our code here. Armed carjackings, things like that. These folks are here. They have committed crimes of violence. However, they did not necessarily get arrested in multiple of these counties for these acts. Prince George's County alone has released 649 people that ICE requested that they detain back onto the streets of Prince George's County. Howard County has released 120 people that ICE requested that they detain back onto the streets of Howard County. When the ICE director was here, he stated very unequivocally that he had just picked up the #2 MS-13 gang member on a traffic violation, that they didn't even know he was residing here because Prince George's County had released him. So this bill, the actual outcome of this bill is to release all of these people with prior appalling, dangerous offenses back onto the streets of every county in our state, unless those exact crimes were the ones that they were arrested for this time. That's what this bill actually does. That's what this amendment actually does.
Absolutely doesn't do that.
In Harford County alone, our 287G program, rape in the second degree, dozens of first and second degree assaults, sexual abuse of a minor, solicitation of a minor, dozens and dozens of controlled dangerous substances distribution charges, first and second degree murder and attempted murder. That's what our 287G program caught people who did these crimes in our county that had no ICE detainers, that ICE did not know about. 287G exposes people here flying under the radar committing egregious crimes. That's what it actually does. ICE did not know about these people. They knew about them only because of the 287G program. That's why they're no longer residing in Harford County, where we've had multiple women murdered, raped and murdered. That's what this amendment does. That's what this bill will do.
Delegate Moon.
Sorry, I just want to make sure everybody, thank you, Mr. Chair, I just want to make sure everybody's referring to the same version of the bill. We had a version sent out at, I believe, 1:19 p.m. with the title Minor Change, HB 1222 Minor Change. And if you scroll to page 2 of the bill, line 14, what begins is a long list of offenses here. And so I just want to make it clear, in counter to what the delegate was just suggesting, the amendment, as I'm reading it, would have Prince George's and Howard counties notify ICE when they have these people for a crime of violence, as you note, but also all felonies, DUIs, gang members, Interpol warrants. Yeah, quite a long list of offenses here, not, as you suggest, releasing these people. It's actually requiring notification in this instance. Just want to point that out.
Delegate Erickson.
Thank you, Mr. Chair. I want to explain why that will not have the desired outcome. 287G screens for country of origin. Without screening for country of origin, a person who comes in who does not have an existing ICE detainer will not be flagged. My local jurisdiction will no longer pick up the phone and call ICE because the person has an accent. This is a question that the form is given to 100% of people who are taken in. That way there's no racial profiling. Everyone that comes in is asked, were you born in this country? If not, where were you born? That is the signifier that tells them to take that charge and that individual and give it to ICE and say, is this somebody you may be interested in? Here's what they've been charged with. Furthermore, as I stated earlier, just because a person has been collected by, let's say, one of these, like Howard County, where I grew up and still love, despite what they're doing, just because somebody's in there for a crime of violence or whatever, doesn't mean that they, or with no crime of violence, doesn't mean they aren't violent people. It just means that they were arrested for something other than a crime of violence today. And as the ICE director sent me, there is a long list of people who have committed appalling and atrocious crimes here, statewide, nationally, internationally. Those folks will not be flagged anymore. 287G is catching new people, so that's the one problem. And if you guys are saying what we can do is we can honor ICE detainers only if the person we've collected today is being charged with a crime of violence, you are ignoring the fact that many people are brought into custody for DUIs, for other types of traffic issues, for minor misdemeanors, but they have a history of extreme violence. MS-13 gang members can also drive a little erratically sometimes and get picked up for it. It doesn't mean they don't have a serious history, but it does mean, under this bill and under this amendment, that they would not get flagged for an ICE detainer by the counties because you have specified there has to be that list of crimes. That is the problem with the way the bill is written.
You want to respond? I'm sorry, I meant Delegate Williams.
So again, it's,
Delegate Williams is late.
yeah, you keep saying crime of violence. It's crime of violence and a much more extensive list. And again, if that person gets picked up for some smaller offense and a detainer is out there for them, that county is going to have to call that person in. That is a change in policy.
Delegate Moon again, then Williams.
It's in this whole section related to a mandatory notification. It's starting on page 2. The covered individual crimes list right there, all of those are mandatory notifications.
I don't see traffic violation.
No, it wouldn't happen on a traffic violation. It's if that person gets picked up on a later offense that is not on this list, but ICE had put a detainer out for them for one of these offenses, there will be a notification. So it's going to be on them not to get picked up for something else. But once they encounter the local government in that manner, they will in fact be called into ICE.
Delegate Williams, then Cardin, then I'm coming back around.
Thank you, Mr. Chair. And I think, we want to, the focus of this bill is, one, to also make sure that everyone within all of our communities feel comfortable engaging in law enforcement. With the 287G agreements, that causes people to not really want to talk to someone if they have an if they have an accent. Just because you have an accent does not mean you're here unlawfully. You can be here very lawfully and have an accent. You can be here on a visa, you can be here from some other means. What we are saying with this bill is that we are not going to harbor the worst of criminals, and we are going to make sure that everyone in all of our communities feel comfortable engaging with law enforcement when they need to engage with law enforcement.
Delegate Cardin, making my way around.
Thank you, Mr. Chair. So I see at the end of the bill, the last page, that there is a requirement for a termination of the program that Delegate Erican was talking about. But I also see what Delegate Moon was referring to on page 2. And I think it's pretty clear. I understand the comment from Delegate Erican, but I'm not sure that it works. It says here that is subject to an active immigration detainer request and has been convicted after June 1 of 2025. So if the institution knows both those facts to be true, they are required to detain them, regardless of whether they were picked up on a minor traffic violation or anything. So I think this is about as clear as it can be without, without being onerous or violating constitutional Fourth Amendment rights. So I'm pretty good with it. So that's the way I read it. I mean, it couldn't be clearer.
Delegate Embry.
Hi, I just had a clarifying question. If a person is convicted of a felony not listed in this section, does this law prohibit local law enforcement from communicating?
No, it does not. They
you.
could still voluntarily communicate with federal immigration authorities on their own if they still so choose so. And so if one of those crimes are not listed. Additionally, I want to go back to Delegate Erican's point about the MS-13 member that was picked up in Prince George's County, which does not have a 287G agreement. Clearly the law works. Clearly law enforcement was doing their job on that day because they picked him up and arrested him. And we do not have a 287G agreement in my county. So to say that it is a necessity, I don't see how your example shows that it's not a necessity.
Delegate Conaway, then Grammer.
Thank you, Mr. Chairman. I wasn't clear. Did Delegate Erican say that some of the people that are being picked up have violations outside of the country that's triggering this ICE detainment?
That appears to be what she said. Delegate Grammer.
Thank you, Mr. Chair. I have a couple statements, brief statements and a couple questions. And I think the bigger political picture of this bill is we're going to do with 287G, and we're going to make sure everybody honors a detainer to a limited degree, and that's the trade we're going to make to kind of do away with this issue. That is what I've been told as I understand it. But I don't think that's what this bill does, and I'd just like to articulate those couple reasons. I think this bill does away with 287G, which is not what's terrifying people. I think the rhetoric is terrifying people. I think that those people are still not going to work with law enforcement. And I think the trade-off in requiring this limited detainer voluntary agreement with ICE, frankly, is not going to work. And for this reason, I'd like to start with a couple questions. What is a felony under 420B of the criminal article? Can someone tell me that?
What is going on? That's the controlled substances. Yeah.
Distribution or?
Possession.
It's possession of a handgun while you're distributing marijuana.
Okay.
And that crime itself is a misdemeanor.
Marijuana or any controlled substance?
Marijuana.
Okay, but not like heroin, any hard drug?
I don't believe that.
Why do we not include the hard drugs?
Moon is double checking my math here.
Is it okay to just wait for him?
Yeah, go ahead and ask your next question.
Well, here's the broader question. So if ICE requests a detainer because someone is wanted for a rape and a murder in Honduras, why is the local charge germane at all? And I'll give you a couple examples. Why do they have to be convicted of a crime of violence here to honor the detainer? What so we hold the murderer that's convicted, but if we charge someone with murder and they are not convicted, but they still are wanted for murder and rape in Honduras, why do we not detain that person? Like, why is?
Delegate Williams.
Actually, we would detain that person. If you look at Section 6, it mentions an Interpol notice, meaning a request issued by International Criminal Police Organization for law enforcement worldwide to locate and provisionally address a person pending extradition, surrender, or similar legal action. So if they do have if they were convicted of a crime in another country and that was sent through the Interpol system, then yes, we would have to detain them.
What if the detainer was for something, I'll give you another example, for something that didn't fall under that particular agreement, and we had someone that we would detain for murder, but if they were charged but not convicted for murder, then suddenly we don't honor the detainer.
If they were not convicted of murder, they were not found guilty of murder, that's how can you say that they committed murder?
Well, I'm not saying that. I think that they clearly, if they're not convicted, they clearly did not be convicted of murder. But why does that invalidate the detainer request? And it gets to Delegate Arakan's question, like, you know, this list of crimes that we have here, frankly, is not, it's arbitrary and it's not germane to the detainer at all.
I think the other concern is, because I'm going back to the Fourth Amendment piece that I mentioned earlier, is that we want to make sure we're not violating the Fourth Amendment of the Constitution and unreasonably detaining someone. And so, as I mentioned earlier, the Attorney General has already provided guidance regarding those concerns. And so that's why that becomes important.
So we're just violating it a little bit?
No, we're not violating it at all under this bill.
Well, I think you're evading the bigger point, which is a detainer is a detainer, and a detainer is issued for a reason. So if it's issued and we happen to have that person for a traffic offense, or if it's issued and we happen to have that person for a crime of violence, like, why are we linking the two here?
Delegate Moon to respond, and I see your delegate.
I mean, you sort of set up the frame of this conversation yourself when you described it as, I don't know what term you used, a bargain, a trade, a compromise. I mean, if you look pretty plainly at what's going on in the bill, it's pulling out 287G agreements and then putting in a bunch of mandatory notifications. In other words, it's creating a statewide standard here. And as Delegate Williams, the sponsor, noted, beyond that, the counties can do what they want with voluntary cooperation as they currently do. But with respect to these prisoner transfers and notifications, this is establishing minimum standards for both the counties that currently want to do less and those that currently want to do more. And we are in the business of drawing lines all the time that seem consensus or reasonable, and this is where we landed.
Delegate Art can, then Phillips, because Delegate Art.
Thank you, Mr. Chair. So a couple things. First, to Delegate Cardin's explanation of why he thinks it's broadly covered, my reading is has been convicted on or after, not before. So they're not looking backwards to see, is this person a bad guy from before? They're making sure that they're a bad guy today on this charge. What I got from ICE was a list of folks who had previous horrifying convictions, but could be caught here for minor issues.
Right.
That means if I murdered somebody on May 31st and was convicted on May 31st, it doesn't count. Equally, if I murdered somebody in another country and it did not go through Interpol, not every murder on the planet goes through Interpol.
Right. But if you murdered someone here prior to this date, you would have been first-degree murder, you would have been sent to Jessup, and you would have been fingerprinted, and at that point, your fingerprints would have gone into the national database that ICE is a part of, and they would have got dinged that you were in Jessup. And therefore, if they were interested in picking you up, they would have ICE would contact Jessup and say, hey, we see that you have someone here in Jessup who is in our database, and we want to pick them up.
But
yes, that's what happens currently.
Yeah, but this says only after the June of this year, the person would have to be convicted. So that's not, this is not, I don't see anywhere in here where it includes prior
But my point is
convictions.
that if they were convicted of murder prior to this year, they should have been picked up by ICE under the current law.
But
Now, if they weren't picked up by
gonna
ICE,
change
that's
it.
not our failure.
We're gonna
That's
ch-
ICE's failure.
We're changing it, though. We're changing the law. So now, there's nothing in here that says, all right, we can debate the timing in here all we want. The other thing was that it was said that this doesn't preclude any of our jurisdictions from suggesting the ICE come pick people up, that there's no detainer on. But the bottom, the way I read the changes, the bottom is that you cannot enter into any agreements.
Correct.
So then the Montgomery County MOU, which is a handshake MOU, would be outlawed. Okay, so then that's not accurate either. So you can't enter into a handshake MOU.
You cannot enter into any formal agreements with federal law enforcement. That would be accurate.
Okay, so that gets rid of that. So then it takes me right back to the beginning where the purpose of 287G is to prevent discriminatory behavior. It is a question on a document so that no one is racially profiling. It's quite literally to avoid racial profiling. You just ask everybody, no matter what they look like or what they sound like,
but earlier you
where were you born?
Okay.
That's the whole point of it, is to avoid exactly what your party always says they're so worried about is discrimination. This asks 100% of people. Were you born here? If not, where were you born? If they're flagged as being foreign-born, then they're sent. Then that goes to ICE, and ICE just says
And again, just
either
because-
yes or no, we have a detainer on them, or no, we don't have a detainer. We didn't know they were here, but we've seen they've committed a crime here, so we're going to flag it. And when the adjudication process is done, we're going to put a detainer on them and come and get them.
Okay, and just because someone's foreign-born, again, does not mean that they're here illegally. In addition, ICE is not providing your jurisdiction or any other jurisdiction any resources with regards to any of these 287G agreements. They are not paying for your officers to do this. They are not paying for the 6-week training that the officers go through. We are utilizing our own taxpayer resources to do ICE's job.
Delegate Eric can, but then I need to go to.
Oh, poor Delegate
Mr.
Phillips.
Chair,
He's been waiting.
my county being willing to train our own people so that we can make sure that no more women are murdered and raped in it, I think is wholly outside the purview of this committee to make the decision on, first of all. But the point of the program is literally to make sure that we are not keeping people committing egregious crimes that ICE is unaware of.
Are the people of the Harford County Sheriff's Office truly not trained to keep the people of Harford County safe from people who would rape or murder them?
Mr. Chair, this is in addition to what we are already doing.
But they can do that already, and they do that already, and they get training to deal with those issues, and they do that.
This is
What this does is it says that if they're convicted of these crimes, we call ICE and say, they're here. You've got 2 days, you got to come and pick them up. Because people who have committed felonies, people who have committed crimes of violence, we're not defending these people. But outside of that, when it comes to enforcing immigration law, which is very clearly the purview of the federal government, we're not going to spend our tax dollars on it.
That's not what the program does. The program is catching people who are not on the ICE detainer list. So we aren't going to be calling them. The people that we caught in our county were not on the ICE detainer list.
So if they're not on the ICE detainer list, then you're saying that they didn't break an immigration law?
They're not automatically on a detainer list just because they've broken immigration law. ICE creates
So this gives ICE the ability to do whatever they want, wherever they want, and use local law enforcement to help them with that? That's your argument.
No.
Your argument is that they should be some kind of almost super law enforcement agency that steps above and goes beyond. And if I'm going too far,
Yeah, no, that's
Delegate
not what I'm
Williams,
saying.
then I believe that's what's being advocated.
No. What we've
Okay,
done
so then
is,
explain to me why,
Yeah,
why would we put money into enforcing federal immigration law when that is their job?
yeah, so we didn't put money in. I did because I live in Harford County. But what I put my money into is to train one of my officers to be able to act as an ICE agent on the ground at my prison so that when folks come in committing crimes, if we think it's possible that ICE may want to come and deport these people, we would send it to ICE and say, would you like to deport this person? Is this person, on a list anywhere? Have they committed crimes outside of the country that you're aware of? Would you like to put a detainer on these? And they make the decision, yes or no. And a lot of times they say no. No, we don't want, we understand the person's here illegally, we don't want to put a detainer on
And that's
them.
what the bill seeks to do. That's what the amendment seeks to do. The amendment says if they're convicted of these crimes and they've been held at the Harford County Detention Center, then they can be turned over to immigration, and they can take the next steps as long as they're subject to that to the detainer that's listed in the bill.
But
that's where I'm confused.
They don't have a detainer yet, that's the problem.
Well, again, if they don't have a detainer, then what are we talking about?
Because the
Then
ICE does not know
why do
about
we
them.
need to worry about, then if there's some other reason that they have committed a crime, then the Harford County Sheriff's Office should investigate them for that crime.
Well, we do, and then we convict them, and then we hold them, and then we let ICE know we have this person that you were not aware of.
Done and done. But we hold them and we give them notice 2 days before and say, out you
We will no longer be
go.
allowed to do that. That's what 287G does. That's the whole point. So now we will not be able to do that. How would
That's
we?
what the bill allows to happen. That is precisely what the bill allows to happen. Statewide.
How would we know they were here illegally if we cannot ask them their country of origin?
That is not what 287G allows.
That is what 287G allows.
There is some kind of, okay, I'm going to stop because I said that I was going to let other people ask questions. Delegate Phillips, Delegate Carton.
Well, Mr. Chair, you kind of went down the path. There are a couple of things. One, the ICE agent himself said that there were other mechanisms for addressing these individuals. And when I asked him a number of questions, we went down that path of how you identify people and when people's names pop. because anyone who was arrested, their name is going to show up on NCIC. That's one thing. But from a policy perspective, we're weighing some things, Mr. Chair, and to my colleagues. One is this idea of public trust for individuals who would come and report crimes and be part of the process. The other, this idea that we are literally communities, law enforcement, doing ICE's job. That's what 287G does. It authorizes local agencies to do their job. And we've now said we've got to debate these two. And if I'm going to debate these two, I don't want local law enforcement to do ICE's job. I want them to do their job and keep us safe, but I also want them to do their job in a way that does not erode public trust and public safety. So I just wanted to share that.
Thank you. Delegate Carter.
Thank you, Mr. Chair. First of all, I don't think there's anything in this law that prohibits a local agency from contacting ICE. I don't see anything in here that prohibits them from doing that. That's number one. Number two is regarding the prospectivity of it. What the bill does allow is if somebody's picked up for a minor infraction and they find out that they were convicted of one of these enumerated crimes after June 1st of 2025, that they would then be required to report that to ICE. That's what the bill does. Why prospectivity? And you had brought up, what if they did a crime 25 years ago where it's one of these horrible crimes? And the answer is that we have a post-conviction, we have a litany of rights that a lawyer or that a person, a litigant, would have to be told by a judge to make sure that they are properly, told of their rights that they're giving up should they choose to either take a plea or get a reduction in their sentence. And what is said now, although it's not gonna be artfully done, is taking this plea or accepting this type of sentence could impact your immigration status. That is different than your information will be reported to ICE. So the state of Maryland could be involved in hundreds, if not thousands, of post-conviction cases where somebody is going to say that their sentence was illegally ascertained. And that would be a horrible, horrible situation for all of us and cost us a lot of money. And that's why it has to be, in my opinion, that's why it has to be prospective. Thank you.
Yes.
We're going to be on the question amendment.
I will be brief, Mr. Chair, but I did some research, and in terms of what somebody raised the question of what happens if somebody's charged with murder in El Salvador, and our State Department has a whole process for issuing federal criminal warrants for people who are wanted for crimes in other countries who have met our standards for extradition. So that takes care of that concern. Thank you, Mr. Chair.
Thank you, Mr. Chair. So let me also tell you, let's talk about very briefly a function that the state doesn't do but still spends resources on. We don't fight terrorism. But after the 9/11 Commission, if you all remember that, I know I do vividly, and they talked about some of the things we needed to fix to be able to deal with these problems going forward. One of those was the problems they found was local and state and federal law enforcement really weren't prepared to be able to communicate with each other. So almost every single state and local jurisdiction in the country adopted regulations requiring not only requirements but funding for when a cop has a local radio, they could literally and talk with both local, state, and federal authorities. That was a massive expenditure. And I think, that was a great time in our country where we said, we want to protect the public, and how can we do that? And we agree with that. And I'm just thinking, we keep talking about the state spending resources, tax resources, fighting, enforcing immigration laws. Like, exactly what resources? Is it the cell in which the immigrant is detained? Is that cell not going to be there if we decided not to detain? Is it the communication? Because if we're willing to pay trillions of dollars, hundreds of millions of dollars for communication devices, but we're actually saying we're not going to pick up the phone and call ICE, and that's the resource we're not willing to spend. Those are the tax dollars it's to actually make a phone call. I think what we're really saying here is we just don't care about this scope of public policy. And I'll remind you, I don't know if she's agitated, but in Delegate Archon's district, I believe that was the district in which the girl was raped on a hiking trail. So this isn't arbitrary. And frankly, it's not a very big number of people that we would be detaining. So that's why I'm frustrated here. We're both saying in eliminating 287G, we're literally saying we don't want to spend a negligible amount of resources, and it really is negligible, to cooperate with the federal government on the worst offenders, And what we're doing in terms of honoring detainers, like here's another example that ICE issues a detainer. Someone who's here illegally has committed a crime in another state, has nothing to do with Interpol. That's a completely valid reason that ICE would issue a detainer. And in that case, in this bill as amended, we're just half-assing it. Like, to me, if ICE issues a detainer for whatever reason, I have absolutely no problem allowing local jurisdictions to work with ICE, because the people they're identifying, frankly, are pretty bad offenders. We're seeing that the jurisdictions that are allowing people back, they're not detaining. These people are going on to commit violent crimes, and the resources that we would expend are negligible. And this bill is drafted, we're going to be hearing the same stories, like the person got out for random crime and committed heinous violent crime. We're just, the trade here in eliminating 287G and doing next to nothing on detainers, I don't think is a good trade at all.
Thank you. Well, actually, I was more responding to Delegate Grammer, but a detainer shouldn't be issued for any reason. It should be issued because the person's here illegally. So that's number one. In terms of the cost, while, yes, in a multi-billion-dollar budget, the cost might be negligible, but for a local jurisdiction, the costs are impactful. We're talking about costs for sending the officers to the training. We're talking about costs in terms of overtime hours for the law enforcement individuals who are processing these things. We're talking about all types of different costs, the ongoing certifications that they have to maintain under these agreements, the paperwork that's related to ICE and everything else. So, I mean, there was an independent audit done of Frederick, for an example. I'm just going to use them as an example. Over a 5-year period, the costs were somewhere between $9,000 to $12,000. Yes, for a state, that might not be a whole heck of a lot of money, but for a local jurisdiction, that can be substantial. And so I don't think we should just write off the costs that really our taxpayer dollars are going to. So I just wanted to just, kind of
All right.
indicate that.
We're on the amendment. There may be people in the lounge. Yes, okay, Delegate Valentine, and then we're going to vote on the amendment, please.
I just wanted to make a couple of comments about the program itself, especially since the testimony dealt specifically with the 287Gs as we use the corrections model. I think it's safer for our communities. Everything is taken care of in-house. There's no contact in the outside with the public, and there's also no unintended consequences with arrestees. It's very arrestee specific. But I did want to look on the last page of this bill. With the wording, I've always liked to look at the wording where it says, the state, a unit of local government, a county sheriff, or an agency or employee may not enter into an agreement, into immigration enforcement agreement. So I look back to the page before that where it says an enforcement agreement includes, it just simply says includes, and says 2 USC sections
or any other federal law as a catch-all, any other. So where would they be bound to work with federal law enforcement? If that's kind of a catch-all, they wouldn't have to cooperate with federal law. That would be my question. If that's the catch-all, any other federal law, they would not have to cooperate.
Who'd like to respond? Delegate Moon? Delegate Moon?
I was just going to say, so for example, Montgomery County has been altered its policy with respect to ICE cooperation to be much more expansive than had previously been done. And when we inquired to find out where this was written or what type of agreement with ICE they had, there was none. There was no formal agreement whatsoever. It was a decision the county made on their own to call ICE when they encountered a gang member, someone convicted of X, Y, or Z crime, and they did it on their own without a formal agreement with the government. And to my understanding, nothing in the way we've written this would change that.
I was going to say that. It specifically says that, but this would prohibit from cooperating on any other federal law the way this is worded. In the last paragraph.
An agreement,
or the next to
right?
last paragraph, if you round it around.
By an agreement.
By an agreement.
They don't have an agreement.
County was mentioned. I want to make sure it's very clear that my district, District 3, the city of Frederick, many of the residents, especially the individuals that live in my very neighborhood, do not find 287G to keep them safe. They actually find it to be, more scary than, particularly for families, for children, and everyone else. So just want to correct that.
Seeing no further lights on. We're on the amendment. All in favor of the amendment, please raise your hands. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11. Chair votes 12. All opposed? 1, 2, 3, 4, 5, 6, 7, 8. Okay. Amendment is adopted 12 to 8. Okay. All right, so, okay, are there any other comments or questions regarding the bill? Delegate Grammer.
One 183029.
183029.
And I won't belabor this too much, but this gets to my main concern, and it applies the detainer provision of the bill to all crimes. I think if someone's wanted for a murder in Arizona and ICE issues a detainer, the crime that a person is detained for that is currently held for here isn't relevant. And I think if we're going to make the trade of doing away with it or prohibiting 287G and any other agreement with the federal government, we should actually make a standard of saying, okay, if you ask for a detainer, we will acknowledge that regardless of what the crime. So with that, I would move the amendment and ask for a second.
Second.
For there is an amendment that has been moved and seconded. Are there questions or comments regarding the amendment?
I was trying to find it. Yes.
Court's indulgence. I need the husher too. That would be nice. It is.
Yeah, I think the amendment is a little, sorry. Thank you, Delegate Grammer, for presenting the amendment. I'm just now seeing this for the first time. It seems really broad to me, to be quite honest with you. I think a little bit broader than what we would like, to be very honest with you. I think it just kind of really kind of guts the bill with regards to the whole purpose of the bill, in the sense of making sure that our law enforcement officers are cooperating with ICE in a way that is related to a specific crime, someone being convicted of a specific crime, and yeah, I mean, and I think it may violate the Fourth Amendment concerns that we had by the way that it's phrased there. And so for those reasons, I can't support the amendment, unfortunately.
Delegate Moon.
Thank you, Mr. Chair. I mean, look, Delegate Grammer, I appreciate your perspective and what you're trying to do here. I'll again highlight, nothing's stopping these counties from calling in additional folks on additional detainers if that's what they want to do. But part of the reason why we're attempting to strike a balance here and come up with a consensus list of offenses is because you don't want people too scared to call for help when they're the victim of a crime and someone is out there harming the community. And frankly, with the policy change that the ICE director told us was a policy change with this administration, that they're making collateral arrests. In other words, the victim, the other people, anyone in the orbit there who just happens to be near the person is going to get picked up by ICE, whether or not they were the victim of the crime or whether they were a witness to the crime, whether or not they live or happen to stand near it. And again, the more petty the offense you allow those collateral arrests for, I think you're going to have less and less willingness from people to call for help and people who want to get these dangerous people out of their community. That's always been the reason for us trying to strike this balance. And again, I mean, there are a lot of people who want to help the immigrants who are not going to like some of the things we just did to this bill in terms of mandating these calls from counties that are currently making no calls. So I just hope you can appreciate the difficulty in getting just to this point in the conversation, though I do respect where you're coming from.
I get the trade, but I would keep in mind that as a state body, we're making the trade on behalf of every jurisdiction, whether they like it or not. I just think that we're not. This amendment does not touch the 287G part of the bill. So if we're doing that to deal with the fears about working with law enforcement, this doesn't touch that at all. I do believe, and I think I'd pitch this question to the sponsor of the bill. If someone's wanted for a murder in Arizona, why is the local crime that they're held for here in Maryland, why is it relevant? And I think that everybody in the end, in their heart of hearts, will agree with this, and I'd just like you to answer that question.
If someone has been convicted of a crime in Arizona, then I'm certain that they would have been held in Arizona. And the same process, just like here. ICE had their opportunity when they were convicted in Arizona to pick this individual up if they had a detainer for that person. And if ICE chose not to exercise that detainer, then they chose not to exercise that detainer in Arizona.
That's not how that works. That's not how that works at all. If someone commits a crime and there's an investigation and then the federal government takes it up and they say, this is the person that's wanted, ICE issues a detainer. It's found that this person happens to be in Maryland. ICE issues a detainer. Like, that's literally how this process works, why the detainers are issued, and it's straight up.
Then ICE can come and get the person.
They can't, though, because we don't detain them. And respectfully, it's because your jurisdiction doesn't detain them. This is a very practical thing, and that's how that works. And I hate to pose it in maybe,
But ICE can pick up a person that they have a detainer for, whether that person is detained here in Maryland or not.
But not as this bill is structured. This bill does not require, if you look at how the bill is required, the notification, the 48-hour, if if that person is not convicted for one of those crimes, these jurisdictions won't even issue the communication. So this is not how this bill works as it is currently.
Mr. Chair, I'm so
It
confused.
mandates that if there is a conviction, then they get that call that is made to ICE. If they are charged, they don't. I accept your premise that if they're charged, then that is in fact the case, that they don't, because they were charged. It's not, again, at that point, and by the way, for how this works, they're going through a process where they're getting fingerprinted and getting pinged anyway. So again, this is where ICE is going to find out one way or the other. All we're saying is, if you're being held, if you're being detained, and you're about to be released after a conviction for one of the crimes that are listed, then they're going to get a call. Hey, this person is here. You've got a detainer on them. You can come and get them. There's actually nothing also in the bill that prescribes a jurisdiction from going beyond that they could decide on their own. And there's nothing that prohibits them from doing that in the bill. That is the most challenging, I think, part of your argument, in that this is somehow, by saying what they shall do, it is somehow prescriptive of them doing anything, of any county doing anything else. It allows the other counties to do those other things. We're just saying we're not going to be effectively deputized by ICE. Having said that, if somebody breaks one of our laws, we're going to inform ICE, and we're going to tell them that they're being detained and that they're going to be released in 2 days, and they can come and pick them up if they have a detainer. That's what we're saying.
Bill, and that's not the question. The question is, we're making this trade, and the trade sucks. And I'd reassert it. What if someone is held on theft of goods for $400, but they're wanted in Arizona for murder?
But Mr. Chair,
It will
wouldn't
not
they be?
apply this bill.
Yeah. But Mr. Chair, wouldn't they just be extradited back to Arizona and then charged in Arizona and held?
Not necessarily.
Delegate Embry, another voice heard from.
Just on this point, local law enforcement respects all warrants and detainers issued for any crime committed in the U.S. That happens all the time. We have extradition agreements with every state. I mean, if they're wanted on any crime, even a misdemeanor, we respect those detainers. This has no impact on that. This does not impact that. If there is an open warrant anywhere in this country for a crime, a state or local crime, that will continue to be respected by all law enforcement in the state of Maryland.
That's not how I see it. And that's not what, from the examples I've seen. And that's part of what I'm getting at.
Respectfully, I just think that is, I understand, I think the point that you would be right is if there were a previous conviction in another state, but no open warrant, then you're right, the language in this would control what they were convicted of here. That's correct. Although, as the chair has said repeatedly, and so has Delegate Williams, they are not prohibited from contacting ICE.
And again, to build on Delegate Cardin's point that he was making, the reason that this is prospective and not retrospective is because when people took pleas or did whatever action they were going to do in advance of that conviction, there's a whole litany of questions, and this is absolutely a collateral consequence for that they would have had to been advised of prior. That's why we're looking prospectively, and we're making it clear, if you do these things going forward, we're going to, and you're detained, we're going to report this to ICE. The vice chair, well, actually, let's go to Delegate Arakan, then.
No, I don't have anything, Mr. Chair.
All right, that's fine. Delegate Arakan, then the vice chair, and then a quick
Okay.
question. Go ahead.
Okay, just to, for the millionth time, re-explain why it would be prohibitive of any type of contact with ICE that goes beyond as prescribed here. If a person comes in, there would be absolutely no way, if they had not already been in the system, because what has happened in my county is that we will bring the person in, ask for country of origin, take fingerprints, send fingerprints to the system, fingerprints come back clean. No one knows about this person. So we say, okay, fingerprints are clean, they have foreign country of origin, we're going to send their information to ICE to see if they are here legally, visa, have no visa, what's the story, do they want to put a detainer on? The way this amendment/bill now is drafted, there is no triggering mechanism for the local authorities to say this person is even an immigrant at all. So there would be no way for my officer to know to even call ICE, because the fingerprints are coming back clean. That's the entire point of 287G, the whole point.
But they've committed a crime in your county.
We do not know that they are here legally, illegally, have a visa, because their fingerprints are clean and do not hit in the system. The only triggering point is the country of origin question. And if we do not ask that, what you're insinuating is that there should be some level of racial profiling going on to call ICE and say, hey, I've got a guy here who committed a crime. Should they call on 100% of crimes? Or only the ones they think could be here illegally? To eliminate the think could be here illegally, which is obvious racial profiling and should obviously not be permissible, which I can completely agree with, we have a country of origin question. It's the only piece that's missing. So there is no way to enter into any type of MOU. I don't know what Montgomery County is doing right now. How in the world do they know if these folks are here legally or illegally? If they can't, how do they know that? Who are they they're just looking at them and guessing?
Delegate Williams and the vice chair. Or maybe Williams. Delegate Williams at all, going once? All right. Delegate Conaway.
Chair, so my only question is, there's a problem with universally asking people what is their country of origin?
I'm sorry, restate your question?
My question is, based on what Delegate Arakan has been said a couple times, is there a problem with asking people what is their country of origin universally?
I don't believe so, no. But going to the sponsor, is there a question there?
Yeah, I don't think so either. We were just going back and forth.
All right, we're double checking?
We were just double checking, but I don't think so.
No.
Well, that seems like that's Delegate Arakan's point, or at least one of her points.
I understand that. Delegate Grammer, then Delegate Kaufman.
Yeah, on the amendment, committee members, frankly, I think this whole issue has a lot of very heated rhetoric surrounding it. I think that when we heard the testimony the other day from the representative from ICE, the way these detainers are issued, frankly, are very limited. All the detainers that we've seen have been really reasonable, and for pretty serious to really serious infractions we've seen. So this is a really simple amendment. It just makes the detainer apply to all crimes, and I don't think the crime a person's committed locally for should be attached to the reason the detainer was issued. And I think it helps protect all of our communities, especially the immigrant communities. I think it's frankly a very reasonable amendment that I think in your heart of hearts we can accept here. So I'd move the amendment.
There was a motion and a second. All in favor of Delegate Grammer's amendment, please raise your hands. 1, 2, 3, 4, 5. Anyone opposed to Delegate Grammer's amendment? 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11. The amendment is defeated. We're on the bill as amended. There's a motion for a favorable and a second. Any further comments on the bill as amended? Seeing none, the vice chair. Delegate Kaufman, I think, had a question on the amendment that's no longer relevant. Delegate vice chair.
Yes.
Yes. Valentine. No. No. Crutchfield is excused. Cardin? Yes. Tomlinson? No. No. Briefly, yes.
Carroll County, we're one of the counties that are currently trying to join the program. We're not in the program. Obviously, if this bill passes, we will not be in the program. I think this is one of those bills where we are reacting to what's going on in DC, and I think it's just a bad direction that we're heading. Thank you.
Right. Thank you. Delegate Embry? Yes. Pasteur? Yes. Tolles is excused. Schmidt? No. Simmons? Yes. Boucher? It's not in the room. Phillips? Yes. Yes. Stinnett? Yes. Yes. Congolo is not in the room. Arakan? No. Taylor? Yes. Simpson? Yes. Grammer? No. Sample Hughes is not in the room. Moon? Yes. Conaway? Yes. Yes. Kaufman?
Yes.
Yes. Williams?
Yes.
Yes. One moment, please. Delegate Boucher, do you wish to be recorded with a vote? No. Delegate Sample Hughes, do you wish your yes? Do you wish to be recorded to vote on 1222? Yes. All right. The motion is adopted for a favorable as amended. All right, that is all the time we have right now. We will announce further voting sessions later today. It's 3:40. Democratic caucus is 3:45. I think the Republicans are having one too. Thank you very much. This has been the House Judiciary Committee.